Okay, so today we're talking about issues of federalism, and the main case that we'll be looking at is the case of Queen versus Dick, and it's a case that's a very challenging case. I find it the hardest case to teach when I talk in first-year constitutional law. I also find it the hardest case to deal with in this class. So if you found yourself a little bit confused by it, you're certainly in company with me, and you'll note from the reading after the case by Kerry Wilkins, a guy that's practiced 30 years in government, he's totally confused by it as well. So there's a lot of open questions that still need to be resolved as a result of the Dick case. But in order to try to at least get a view on some of those challenging issues, as usual, it's important to put the case in its broader legal and political and social context. And part of this takes us right back to the beginning of the courts in 1763 when the Royal Proclamation was promulgated. You'll remember the purpose of that document was to separate Indians from local colonies, from local settlers. So there's kind of a federalism almost that's embodied in the initial statement of Crown policy as to how First Nations would interact with the Crown. It would be the imperial Crown, the distant Crown, that would engage with Indians, not the local peoples. And there's some bolded wording here that I wanted to just emphasize. Whereas it is just and reasonable, the Crown says, and essential to our interest and the security of our colonies, that the several nations or tribes with whom we are connected and whom live under our protection should not be molested or disturbed in possessions in the parts of our dominion and territories. So, Crown saying that there are nations in North America. There are tribes in North America. Their lands should not be molested or disturbed. Their lands should not be molested or disturbed, which the Crown also calls our lands. Right? So there's that kind of double language. And they make their royal will and pleasure known in this relationship between nations and the Crown, which is that no governor or commander-in-chief of any colonies of Quebec, East Florida, or West Florida do presume under any pretense whatever to grant warrants of survey or to pass any patents for lands beyond the bounds of their respective governments. Local governments are not to survey Indian land, they're not to patent it, they're not to put it into fee simple and then register it in their own registries. And no governor or commander-in-chief of any of the colonies in America do presume for the present to grant warrants of survey or pass patents for any lands beyond the heads of sources of any rivers which fall into the Atlantic Ocean. So even beyond those 4 colonies, in other parts of the land that's considered British North America, no surveys, no patenting of land, because these things are reserved to Indians. And then they do say this is to prevent frauds and abuses. Remember, you don't want local people dealing with Indian lands, you don't want local governments dealing with Indian lands because of the incentives they have to take those lands, because they get the most direct benefit from it. So the Crown says, we do, with the advice of our Privy Council, strictly enjoin and require that if the lands are going to be purchased for us in our name, it should be in a public meeting of the Indians for the purpose of entering into these agreements. So again, treaties are to be with the imperial Crown, not the local government. I know I've repeated this 2 or 3 times now in the course, but it's important now, at this moment, to think through federalism. This promulgation of the Proclamation, as you know, was accepted at Niagara by 2,000 people representing 22 nations in 1764. Again, this idea of nation-to-nation relationship. You'll remember referencing the heart in both of these identification of rights here. In other words, this understanding, looking at the Aboriginal perspective on the meaning of the right at stake, was to be this nation-to-nation relationship. come to 1867, 100 years almost later, and you find a replication of this relationship in Section 9124 of the Constitution Act 1867. The exclusive legislative authority of the Parliament of Canada extends to all matters coming within the class of subjects next hereafter enumerated, that is to say, Indians and lands reserved for Indians. So the federal government has exclusive legislative authority in the matters relating to Indians and lands reserved for Indians. And you're going to see how far we've got from that kind of square understanding, exclusive legislative authority being in the federal government, to where we get to in the Dick case. Now, as you know, this was partially eroded in the St. Catharines Milling and Lumber Company case, although not completely. Section 109 of the Constitution Act 1867 reserves interests inland to the Indians because they're considered interests, they're considered any interest other than the province in the same. So the province gets all lands, mines, minerals, and royalties in their jurisdiction as it was prior to Canada being confederated in 1867, but they get those lands subject to Indian interests. So you have to remove the Indian interest in land before the Crown and the right of the province gets the opportunity to draw royalties from the lands. Generally how it should work, except when you come to British Columbia, right? For now 140 years almost, and more I guess, British Columbia has been taking royalties from lands directly that should belong to Indians, as we saw in the Tsilhqo'tin case. But Section 109 kind of reproduces the idea that the province are hands-off from dealing with Indian interests until such time as those interests are surrendered. Then in 1973, there's this case called Cardinal versus Alberta. I didn't have you read it. But in this case, there was a treaty Indian that was hunting on his home reserve in Alberta. He caught a moose, and then he sold some of that moose to a non-Indian. And under the Provincial Wildlife Act, it was an offense to traffic in big game, like moose, unless you had a license under the regulations. And he said, but provincial law should not apply to my reserve. And the province said, oh yes, it should, under the Natural Resources Transfer Agreement of the 1930s, which we looked at already in the Métis context. The province says that all laws of general application apply to Indians, whether they're on reserve or off reserve. That's the province's argument. He says, no. 9124 says the responsibility for Indians and lands reserved for Indians is in the federal government. And so there's an argument that the Indian Reserve is an enclave, a federal enclave immune from provincial jurisdiction, immune from the application of the Natural Resources Transfer Agreement. So that's the conflicting view there. Province says wildlife law is a law of general application under the NRTA, gets this conviction contrary to the Act. The First Nation here is saying there's a force field around the reserve, right? It's excluded, it's lifted out of provincial jurisdiction and put only into federal jurisdiction. The court rejects the argument of the Indians. It accepts the argument of the province of Alberta, and it says Indian reserves are not enclaves removed from provincial reach. As long as the province enacts legislation that's inter vires under Section 92 of the Constitution. So as long as the provincial legislation is in its pith and substance, dealing with matters that's within its sphere, then it survives. It's held here that the province is not trying to deal with lands reserved for Indians and Indians. It's just trying to deal with property and civil rights in the province, in this case, the management of game. So that's kind of a change, a big change, in fact, from the Royal Proclamation, many of the early treaty understandings, the Indians certainly understanding of the meaning of the right at stake. So where we get to in 1951 is another attempt to extend provincial laws of general application to Indians. Not actually lands reserved for Indians, just to Indians. So in other words, what happened in the NRTA in 1930, which only applies to the prairie provinces, the Parliament tried to extend across the country and make all laws of general application applicable to Indians, subject to some exceptions, which we'll look at here now. So here's the language, and it's important to read it, even though it's very convoluted. It's a very poorly drafted section. Subject to the terms of any treaty or any other act of Parliament. So those two exceptions, subject to those two things. All laws of general application from time to time in force in any province are applicable to and in respect of Indians in the province. So there we go. That's what's applicable to Indians. All laws of general application in force at any time in the province are applicable to Indians. But then we get some more exceptions added. So you've got exceptions before the Proclamation of General Application, then you've got some exceptions after that. So, except to the extent, that is, laws of general application apply to Indians, except to the extent that those laws are inconsistent with this Act, meaning the Indian Act, or the First Nations Fiscal Management Act, or with any other order, rule, regulation, or law of a band made under those acts, and except to the extent that those provincial laws make provision for any manner for which provision is made by under those acts. Here comes out at this point. But what you've got here is a system of paramountcy that's being created in favor of Indians in a few particular instances. So general laws, provincial laws of general application. You might ask, what are provincial laws of general application, as opposed to just provincial laws? The Dick case is going to try to give us an understanding of that term. Basically, the section of the Indian Act says provincial laws of general application apply to Indians subject to or accepting treaties, any other act of Parliament, the Indian Act itself, the First Nations Fiscal Management Act, or any band, order, rule, regulation, or law that should be made under the above acts. So these are the fields in which you should have a paramountcy in favor of the Indians.
Is that what the last line says, is the fifth point there?
I think that's what the last line says there. Although it's really hard to read,
Yeah.
right? Or make provision for any matter for which provision is made by or under those acts. I think that's what it means. It's not 100% clear. But hopefully this at least orients you to the section. Right? Here's when provincial law applies. We're going to find out what this means in a moment. And then here's where you get federal paramountcy. If a treaty is in place, the provincial law doesn't apply to it. If an other act of Parliament is in place, the provincial law doesn't apply. It's dealt with in the Indian Act already. The provincial law doesn't apply to it. It's dealt with by that act. Or if a band makes a law under what? Under these acts, then the provincial law doesn't apply. There's no reference here to Section 35, because obviously this was drafted in 1951. and then the amendments took place, I think, in the 1970s to move it from Section 87 to now Section 88 of the Indian Act. You can expect, I think, that the new Justice Minister will change this.
We hope so.
Because there's just no updating for the past 30 years of jurisprudence in what's found here. But what this does, of course, is it makes it very convenient for the provinces to deal with Indians because they don't have to single them out. They just have to pass general laws. As long as their laws are fifth in substance, under Section 92 authority, they apply to Indians unless there's one of these 5 exceptions that kicks in.
So,
Yes.
if this is the Indian Act, Section 88.
Yeah.
And all these things are exceptions, and then you have at the bottom, Section 88 does not apply to lands reserved for Indians.
Yeah. What do you do about that, right? Because the language, as we talked about here, says, whoops, all laws of general application applicable to and restricted Indians. Like the constitutional language is on 9124 is Indians and lands reserved for Indians. So how is it that you get provincial laws applying on Indian lands when you actually don't have the statutory permission for that to occur? It's assumed often that intent should be there, but you've taken statutory interpretation, most of you. You know, if there is a specific constitutional provision that phrases a broader scheme, then I don't know why this lesser scheme should be read to include the broader scheme. But that's what we have in Section 88. So that's the statute. The statute doesn't, just to reinforce, doesn't mirror the language of Section 9124, and furthermore, it doesn't seem to follow the 250-year-old constitutional tradition of the Royal Proclamation, trying to separate Indians from provinces. So now let's look at what laws of general application mean by understanding the Dick case. So here we are in 1985 before the Supreme Court of Canada. And the facts are that this man, Arthur Dick, was hunting in his traditional territory on his traditional hunting grounds as part of the Alkali Lake Band. He was hunting in his traditional hunting grounds, but off of the reserve, and he doesn't have a treaty. So here's Alkali Lake, part of the Tsilhqo'tin Nation. And he's off the reserve, but in his traditional territory. There's no treaty he's ever surrendered any of his land or ever allowed for any kind of regulation of his right to hunt and fish. And when they go out hunting, they go out for days, sometimes months at a time. The court calls this a foraging party. Their purpose is actually in May here to go out fishing. The month of May in Shwetmik or Shuswap is Tsilhqo'tin, which means time to go fishing. But when you go fishing, you're not going to carry all of your groceries with you across the land to get out there and take those fish. As you're going to the site, if you find a deer, you're going to kill that deer, prepare it, and use that for food as you're continuing your purpose. So there, the party's out hunting, again, traditional territory, off reserve, non-treaty, kills a deer as part of this fishing expedition. Then a wildlife officer comes along, as well as 4 RCMP officers, and finds that this party headed up by Arthur Dick is in possession of deer, is in possession of fish, and it's a closed season for both taking deer and taking fish under the Provincial Wildlife Act. And so he's charged with counts contrary to the provincial legislation. And so the question becomes, can this Provincial Wildlife Act apply to Indians of its own force, such that the conviction will stand? Or if it can't apply, if it cannot apply to Indians of its own force, is the Provincial Wildlife Act referentially incorporated into federal law through Section 88 of the Indian Act? That's kind of complicated. We'll talk about that. The court's going to make the conclusion that it's probably not the case that the provincial law applies of its own force to Indians. But the court's going to find that the provincial law is referentially incorporated into Section 88 of the Indian Act. Get that? Provincial law is as if it is federal law under the Indian Act. So when the province has enacted this law, if it's referentially incorporated, it's as if the federal parliament passed it, as opposed to the provincial law passing it. That's going to be what we're heading to here. That's what referential incorporation means. The provincial law is by reference takes on that federal power. So why might the British Columbia Wildlife Act not apply to Indians of its own force, or ex corporio libore? Well, the evidence here is that the Wildlife Act strikes at the core of Indianness. And if provincial law strikes at the core of Indianness, it would conventionally just be read down as to not apply to Indians. And why does it strike at the core of Indianness? Because this lifestyle that we've described with that map I had on the last board gives shape and meaning to their life. You know, going out in these kinds of parties, exercising their rights in this way. Why does it give shape and meaning to their life? Because it feeds them, it provides sustenance, it helps to clothe them, you know, as they prepare the hides for coats and coverings and shoes, etc. It's very important for ceremony. Often when you take the first deer or the first fish, there's a remembrance of your ancestors in doing that. And so you give thanks to your ancestors for preserving the resources that you can then enjoy them today in the present. Right? So it's like each time you have this experience of killing something, there's also a remembrance of the inheritance that you've received, the conservation that you've been endowed with that allows this to continue. It's also a teaching opportunity where the older people in the group take the time to help others understand where the fish might be more plentiful or abundant, in what season, where the deer, the moose might be plentiful or more scarce in another season. So that teaching is very much a part of it. It's the way you transmit your values as a community. It's the way you transmit this value of conservation to make sure that you don't take more than you need, as Michael Ash testified, an anthropologist testified here in this case. In other words, what it does is it replicates the Tsilhqo'tin legal tradition. It's out on the land by engaging in this activity that you're in law school, right? That you have lessons given to you when you find the apprenticeship, the articling that you need in order to take up and practice the standards for judgment that your group has, right? The way that you set criteria for what's proper and appropriate. And so in this case, since foraging is at the center of what they do and are as Tsilhqo'tin people, the Wildlife Act impairs Indian status. It impairs the capacity of Indian peoples. And for this reason, the court draws the conclusion on page 707, on the basis of this assumption, subject to the next question we're going to look at, it follows that the Wildlife Act could not apply to the Indians of its own force, so ex corporio vigore. So that's the first part of the opinion.
Can I
Yes.
just ask a clarification question? I couldn't quite figure out why the court was talking about making an assumption rather than deciding on the first issue. That language threw me.
Yeah, I can't
Okay.
understand that either. But I'm glad you asked it, because everyone else should be similarly perplexed. And then what's even more perplexing is they assume that, rather than say it's proven by the trial and the court, and then when at the end of the judgment, on page 710, when they talk about both these issues, and I'm bracketing, they haven't talked about the second issue yet, but he says, I will answer the constitutional question as follows. Section 3.1 and 8.1 of the Wildlife Act, being laws of general application in the province of British Columbia, are applicable to the appellant, that is the Indian, either by referential incorporation under Section 88 of the Indian Act, or of their own force. What? I think he just said something like opposite to that on 707, that it follows that the Wildlife Act could not apply to Indians of their own force. And at the end, he says, or of their own force. So I'm just confused. I have tried through 20 years to make some sense of that, and I've just not got there yet. And it may be that my mind is just not, it could be weakness in me. It really could be, because sometimes it takes me 3, 4, 10 times to understand what's going on in cases. And, so as you read cases, you hopefully will feel a little bit comforted by that. It's not easy. But in this case, it's just, I feel like, oh, there's got to be something here, but I've not found it yet. So anyways, that's the first issue. The Wildlife Act probably doesn't apply to Indians of their own force. The second question is, why is the Provincial Wildlife Act referentially incorporated as federal law? Because they're going to make that finding, that this Wildlife Act, this provincial law, is as if it were federal law. Why? Well, first of all, the court makes the point that the Wildlife Act applies to Indians as a law of general application because of the Indian Act. So here we go. Provincial laws are not referentially incorporated if they impair the capacity and status of the Indians. That is, provincial laws are not referentially incorporated, or they're not laws of general application if they impair the status and capacity of Indians. Indian status and capacities are only impaired if the legislature's intended to discriminate against Indians.
So how do you prove they didn't?
Well, here we go. While the effect of the Indian Wildlife Act may impair Indians qua Indians, there was no intent here by the provincial legislature to single out Indians for special treatment or discrimination through the act. So this is what, as long as the provincial government doesn't intend to impair the status and capacity of Indians, it doesn't sit there and say, oh, what can we do that will narrow or change who Indians are, as long as they don't think that thought, it doesn't impair their status, even though the effect could be to totally impair it. Yes.
Well, that intent, could be impossible to prove, and then it seems that if you have evidence, the effect is that it's affecting Indians, the core of their Indianness or their capacity and status as Indians. It just seems like such an arbitrary distinction.
It does seem like an arbitrary distinction because you do have evidence here that in fact the effect does impair the status and capacity of the Indians, but the court is saying no worries because they didn't intend that impairment.
So this is 1985 and the 1982 Constitution Act passed.
That's right. So they didn't argue a Section 35 issue here.
But I'm just saying that, I mean, if they intended to single out Indians for special treatment or discrimination, that would violate the Constitution equality provisions anyways. So basically, that means that anything save discrimination is valid.
Okay, so let's take this apart. I mean, first of all, under 9124, this is a matter that's of pith and substance intended to deal with property and civil rights in the province. So the intent is just to deal with animals, not Indians. Right? That's why this survives, because its intent is properly focused under Section 9.1. But we have evidence here that this impairs the status and capacity of Indians. The effect is one of quite significance, but the court says that doesn't defeat the law, doesn't make the law one that's not of general application. The law is of general application because it didn't intend to discriminate or single out Indians, even though the effect is there. Right.
I mean, it seems part of the confusion is this mixing of a general application analysis with a pith and substance analysis. I mean, really what's going on is it's a pith and substance analysis.
Yes.
It seems to me, and they're saying that it's a 9213 law, but it's kind of confused and masked by this general application test. I don't know why they don't just directly
Yeah.
go to pith and substance.
They could have written a direct pith and substance analysis here, but they don't. They're trying to deal with the general application stuff under the Indian.
That's what I was gonna say, it seems like they're creating a new federalism realm, like only to deal with this issue regarding the Indian Act, rather than like all of the other doctrines of federalism that have been used. Like, I can just never see this language being used between like, in any other capacity, and it's
Yeah.
like federalism gets its own little, I mean, it's bizarre.
Yeah, it's bizarre. Now, there was other comments?
So if you look at the Wildlife Act
Yeah.
and you think back to Johnny MacDonald and the education to take the Indian out of the child, what's,
Yeah, so this is obviously part of a broader process of trying to assimilate Indians, right? In that case, it's the federal government passing regulations that remove Indians from the reserve. In this case, it's the federal government giving permission to the provincial government to have their laws apply to Indians without kind of Indians ever getting involved in the process.
Seems like I'm just drawing parallels to Section 15 jurisprudence.
Section
and do
15
you think
jurisprudence?
it would, like, I can't believe that a court today would look at this and think that that's okay. I mean, just thinking about substantive and formal equality, I mean,
Yes,
you can't just discriminate against someone because you didn't mean to.
yes. This is a good point, right? Our standards under Section 15 of the Charter of Rights and Freedoms is when you think about discrimination, it's not just intent, it's not just intent that you look to, you also look to effect. And if you find the effect of discrimination, even if it wasn't intended, you would have a charter violation there subject to Section 1 analysis.
I'm guessing that even if this decision came later in 1985 than when Section 15 came into effect, the lower courts, it wouldn't have been argued this wasn't effective, so it couldn't have any up. Has this continued to be applied?
So this might not now. This is a great question. What is the value of this case argued before the charter was really being argued in 1985 around equality? The Aboriginal Treaty Rights argument wasn't argued here, so you might say it's of little value. Our analysis would be different for the reasons that everyone has just given here. But for some reason it's not. This still is the law, that provincial laws of general application apply to Indians as long as the provincial government doesn't single out Indians. And even if those laws have a detrimental effect to Indians. Like they actually change who Indians are. It's discriminatory against them. Those laws could still apply because they're federal laws that are, provincial laws made federal law here. Maybe, right? Everyone's proceeding as if this is the law of Canada, despite, that's why I'm saying the Justice Minister is probably going to get around to doing something about this, but this is what guides. Let's talk about some more here. So why can the province regulate Indians, qua Indians? Because this is a matter of federal parliamentary intent. Right? Because the federal government passed the Indian Act, had the intent to give over to the provinces the ability to have this occur. So there's two classes of provincial laws that apply to Indians. Those provincial laws which apply without touching Indianness, the court says, like traffic laws. There's nothing that's kind of impairing their status and capacity there when you drive a car, that's what it says. And then secondly, another class of provincial laws which regulate Indians qua Indians are thus referentially incorporated as federal law through Section 88 of the Indian Act. That is, provincial laws which regulate Indianness would not apply without Section 88 being in force. It's the power of Section 88 that allows that discrimination to occur to diminish or affect the status capacity of Indians. Because the court presumes that there are some laws that could apply even without touching Indianness. Now this presumption, the first presumption I think is questionable. That doesn't seem to accord with the Royal Proclamation, where it's just and essential to our interests not to molest or disturb Indians, right? To have the more local government deal with this group of people. The idea is a check and balance, have the more distant government involved. So I have a problem with that one. Then this second one is I have an even greater problem with, because here's one of the points we were talking about. Why is provincial intent more important than First Nations adverse effects when considering the application of provincial law, or when considering the referential incorporation of provincial law as federal law? Like that's the question everyone was asking about Section 15. What? Why is provincial intent more powerful there than these First Nations adverse effects? Presumably because the Parliament intended that. The Parliament was the one that set up the scheme to allow the provinces to have skin in the game, to allow their laws to apply to Indians when it affects the status and capacity of Indians. Why is there very little paramountcy in favor of Indians and lands reserved for Indians in Canada? Why is it just those 5 exceptions that we talked about earlier? Why aren't there enclaves of provincial jurisdiction within, or sort of federal jurisdiction or Indian jurisdiction within the sphere? Here's how I ask it. Why do provincial and not federal or Indigenous peoples' laws regulate the bulk of Indian affairs? Again, one answer is because that's what Parliament intended. But that doesn't seem to accord with Section 35. So what are the implications here? Through Section 88, the federal government delegates to the province, my loaded words, the daily application of colonialism within First Nations. On the ground, day to day, the way that things unfold gets to be the provincial governments. It leaves little jurisdictional space for Indigenous governance, right? If it's covered by a treaty, the Indians can have it. If it's covered by the Indian Act, which you know is very narrow, the Indians can have it. If it's covered by that First Nations Governance Act, again narrow, the Indians could have it. If it's covered by any other act of Parliament, which there are really none, the Indians can have it. But so really, there's little jurisdictional space for Indian governance. But it gets worse. This section even inhibits provincial governments from considering how their general laws would impact Indians. right? Because if the province considered the effect of its laws on First Nations, this would be potentially ultra vires the province, right? Because you would then be singling out Indians for special treatment. So the federal government doesn't have to deal with Indians and their day-to-day affairs because they've, through Section 88, just given it over to the provinces to pass their own laws, which would referentially incorporate as federal law. And the province doesn't have to think about Indians, because if it did, it would be ultra vires. No one's thinking about Indians in the day-to-day nitty-gritty of affairs on reserves.
And yet we're still wards of the government.
This is wards of the government in action. Right? Where's the agency of Indians here? Where is their ability to pass law and influence even their own affairs? And it just seems to be all taken up.
In the paper that comes after the readings, it says that band councils can still override these provincial laws. And does that mean also provincial laws are referentially incorporated through Section 88?
That's right. But the thing is, so yes, it is true. There's a paramountcy for band councils through their own laws to override provincial laws of general application, their status capacity. But the kinds of laws they have authority over are like beekeeping, managing cattle, deciding who gets to hold which piece of land on the reserve. Like the scope is just so narrow that it really doesn't have an effect on things that really make a difference. Health, education, welfare, allocation of more general social goods.
In that piece, they were discussing how this affects treaty rights and how it kind of provides more protection than Section 35 does.
Yes.
And I'm wondering if that also applies to the taking up of lands, or is it just like a federal or provincial law of general application?
Yeah. So this is the question: when you've got a treaty right that's subject to the taking up clause, I think you would generally deal with that under the Mikisew case, which is requires consultation to make sure that that land is taken up in a way that doesn't that substantially addresses the Indians' concern about that. And then if you get to all the land being taken up, then there might be an extinguishment analysis. But it doesn't seem as though the court is putting those two pieces together, the provincial power to use their authority, because under that taking up clause, the authority comes through the treaty, and here the authority is coming through the federal/provincial power. So I don't think that it's going to have much of an impact, although there's more thought to give there. Yes.
The question he made about the authority or the laws that the band councils can make, those band council laws can only be made with agreement or with acceptance from the Minister of Indian Affairs.
That's right.
You can't just make them.
Yeah. So you might not remember, because it was, I think, our first or second class, the way the bylaw power works under the Indian Act is you pass something, say you want to keep bees, and so you pass that, what's called a band council resolution. You send it over to Indian Affairs. If Indian Affairs leaves it for 40 days, it becomes law. But if they send it back to you, it's not law. So in other words, the federal government has a power of disallowance in relationship to Indians making laws through the Indian Act. And that's very aggressively used quite frequently to make sure that Indians don't stray beyond those narrow beekeeping and fowl and cattle keeping provisions. So this is an important moment in the entire sweep of the course to recognize that jurisdictional space for Indians is kind of all swallowed up by the federal government giving the provincial government power to pass laws in relationship to Indians, and then the provincial government can't even think about Indians in passing those laws, because to do so would be ultra vires the province. Now, there's a complication we're going to talk about in a second.
So just a question on that. When I was reading through that kind of idea of not being able to get the intent and the effect, would there be any difference potentially in how someone looked at it if the intent in looking at the effect was to make sure that its impact was not a negative impact, if it was treating someone in a, singling them out for special treatment and that treatment being positive or at least of less impact? Does that change?
Yeah, so under equality jurisprudence, that's not discrimination necessarily to be able to give a benefit as opposed to a burden. But in this case, which is not the equality jurisprudence, if there's even a benefit or a burden, that could be singling out. That's in Pippin substance, not a 92 concern, and therefore ultra vires a province. Yes.
So, just to go over that again, so the Wildlife Act couldn't make an exception for First Nations people, and has that ever, like, no one's ever tried that?
Yeah, because now basically we're dealing with the Wildlife Act on the basis of Section 35, not on the basis of 9124. But of course, it's not just the Wildlife Act that applies to Indians. So in other instances, there's all sorts of provisions that take up life. You can actually make that exception. So just like they couldn't change the Wildlife Act to say, oh, Indians can maybe have this open season, or they have this benefit. It seems as though that could be ultra vires the province.
So for this whole weird loop, that is connecting the province to the federal government and all of the mess this is causing, for that to change, would it just Section 88 would have to change, so it would have to be the federal government? Because this seems to have kind of tied the hands of the province. Let's say if they wanted to go, wait, no, we were going to change this.
So there's three things that could change. One is the Tsilhqo'tin and Grassy Narrows case might be moving us in a different direction here. I'll explain that in a second. But another thing is the Indian Act could be amended, and you could have a paramountcy provision for Indians on reserve where provincial laws of general application do not apply there. And that would be kind of a federal preemption of provincial law. Or you could find in Section 35 some self-governing power that Indians had, and the provincial law could not affect the Indian law unless it was justified in accordance with the Sparrow type analysis. So what's the way out of this mess? One way out is the federal government passing legislation and putting some paramountcy in, or deleting that provision of the general laws of application applying. Secondly is if we ever get a stronger recognition of governance, it is there, remember, in the Campbell case, in the Seeley case, in the Chippewa-Sarnia case, and many cases recognize that there's a power of governance, but it's not been applied. But if that ever came through a stronger Section 35 analysis, that by its own could potentially oust provincial laws of general application when they infringe Aboriginal treaty rights. So let's talk a little bit more about this Tsilhqo'tin stuff. So the court there said in Tsilhqo'tin that provincial powers are limited by Section 35(1) of the Constitution and Section 9124 of the Constitution. So in that case, the Forest Act, that is the provincial law, applied to Indians prior to the proof of Aboriginal title. But the Forest Act, or the provincial law, would not apply to Indians after Aboriginal title had been proved. So at a certain level, this Forest Act, which is a law of general application like the Wildlife Act, is ousted by a finding of title. And then the court finds the province could amend the provincial law to apply Aboriginal title post-proof of Aboriginal title, as long as it was regulating tidal land and not dealing with the powers of alienation. So they say interjurisdictionality does not apply to benefit Indians because it's not the dominant tide of jurisprudence. And the court actually says Aboriginal rights have nothing to do with the core of federal power. What's that? Sure. So let's go through that one more time. Provincial powers are limited in two constitutional ways. 35(1), right? If the provincial law is going to apply to Indians, it has to justify that application. Secondly, if the provincial law is going to pass a law, it has to be under 92. It can't be under 91. It can't make a law for Indians and lands reserved for Indians. So, the Forest Act applies pre-proof of Aboriginal title land, because there the province is regulating property and civil rights of the province. It's not singling out Indians, because it's not even thinking about Indians having title at that moment. But when Aboriginal title is proven, the Forest Act no longer applies. It's now Indian titled lands. But the province could amend the provincial law, or could amend the Forest Act in this case, to apply to Aboriginal title land post-proof, as long as it's dealing with regulation of the land for the purpose of conservation. It's kind of not singling out Indians again. It's just passing conservation law general, even though the effect might be such that could really hurt the Indians. It seems as though that's okay under the Dick type of analysis. So, interjurisdictionality does not apply. It's not the dominant tide of jurisprudence. Aboriginal rights have nothing to do with the core of federal power. Yes?
I'm just confused on the point of the Forest Act. What would be changed about it for that to be amended just so that it does apply to Aboriginal?
So I guess you would have to say something like, for greater certainty, the Forest Act applies to Aboriginal title lands. And then, as long as it's the general application stuff, that it's only applying to Aboriginal lands for the purpose of conservation, like fire control, whatever, then it's okay.
I mean, the court looked at the Forest Act, which said it applied to Crown lands, and then analyzed what Crown lands meant, and found it didn't include Aboriginal title land. But I find it a weird thing, because still, to amend it so that it applies, it would seem hard to get around a direct reference to Aboriginal title land, which then means the province is legislating explicitly with respect to Aboriginal title land.
Yeah.
So it's weird that the chief said, I add the obvious, it remains open to the provincial legislature to do this, when the previous jurisprudence said
It wasn't obvious. In fact, you couldn't do it. So, you see why I started out this class with like, this is confusing stuff.
I thought, in that case, it said that if they amended it to apply to Aboriginal title land, it would have to pass a justification analysis.
Would have to pass the section 35(1) justification analysis, but the 9124 analysis is still open, right?
Yeah, I was just going to say that the section 35 has to be logically subsequent to the different substance. There's no law if it doesn't pass the different substance, there's no valid law
Yeah.
to run through.
That's right, the provincial government doesn't have any authority to, well, does it? This may be an overstatement. I'm going to say it this way and maybe revise. The provincial government doesn't have any authority to pass laws by virtue of section 35(1). You would think the authority only lies in section 92. So you need to have the 92 analysis before you have the section 35 analysis. But it seems as though section 35 is kind of invigorating the province to do stuff, even if it's not necessarily rooted in 92. It seems as though that's what's happening here.
I'm just still trying to wrap my head around this. If it's the making of the distinction that is what makes a provincial law ultra vires, would it not be that any law where they try to exempt Indigenous people or apply any different regime would instantly become ultra vires? So the only thing they can do is say this also applies to Aboriginal people equally along with everybody else.
Yeah.
Has there ever been a situation where like there's been a section 35 remedy that has thereby made a provincial law ultra vires because suddenly the way it's being read is making a distinction, or is the court the only one who's allowed to do that to a provincial law, or?
Yeah, so it does seem
I'm
as though.
sorry if this is a tangent. I'm
No,
just
it's actually
very
on
confused.
point, and it seems as though the court is the one that's making up the rules of federalism here. It's now not Parliament. It's saying, okay, provincial laws of general application that apply to Indians. It's now just kind of some kind of 35 realm, loosely coupled with the 92 realm, that says, okay, provincial laws of general application on the forest apply to regulate Indians on Aboriginal title land. Did you have a question? Yes?
I had a question, but I think I understand.
Okay.
So, just a question, when you were talking about conservation, were you talking about the Wildlife Act?
It could be the Wildlife Act, but actually in the Aboriginal title context, it's more likely they're talking about pesticides. If there's a law of general application that allows the Forest Act to make sure that there's not disease in the forest, or if it's the provincial law of general application that's, fire control can take place on Aboriginal title land, that's the kind of stuff that it's referring to.
Okay, so I was told by a person who works for forestry that their mandate is to sell fiber. If their mandate is to sell fiber and they're using the Constitution or the conservation.
So this is a good question. So this is what I mean here. The province can't pass laws to alienate Aboriginal title for its own purposes. The province can't say, we now amend the Forestry Act to allow the province to cut so many cubic feet of timber to get fiber off. That alienation would be impermissible. It would be contrary to Section 35. But regulating that land to ensure that there is a stand of timber and that the disease in that forest or the fire in the Aboriginal title forest doesn't escape and become the problem for the provincial forest, I think is what the court's saying is permissible here. Okay, let's see if we can do just a little bit more. Grassy Narrows. Broadly put, provincial laws of general application apply to lands held under Aboriginal title, subject to important constitutional limitations. Remember we did this through Section 88 before? Provincial laws of general application apply to Indians, not even Indian lands. Now we've got provincial laws of general application applying to Indian lands held under Indian title without the Parliament ever saying a word about this. These limitations on provincial power derive from Section 35 and 9124. So now I ask, does this same analysis apply to Indian reserve lands, not Aboriginal title lands? And you can say no. There's no similar 9213 interest in reserve lands, right? Property and civil rights in the province shouldn't apply to reserve lands. And textually, of course, you know, that Section 88 only says it applies to Indians, not lands reserved for Indians. But then the Grand case back in 1984 says reserve lands are the same as Aboriginal title lands. The interest that Indians have in their title lands is the same interest that they have in their reserve lands. If that's the case, now we've got Grassy Narrows and Tsilhqo'tin saying that provincial laws of general application apply to lands held under Aboriginal title, you might be able to also say provincial laws of general application apply to lands held under reserve status, if the court's going to hold that analogy in Garand. Or getting into detail now, as if I haven't been for this entire hour. But it's confusing. The court in Tsilhqo'tin emphasizes cooperative federalism. Quote, paragraph 149. Constitutional doctrine must facilitate, not undermine, what this court has called cooperative federalism. And as such, a court should favor, where possible, the ordinary operation of statutes enacted by both levels of government. The challenge with that, of course, is there's no Indians that are allowed to participate in the laws of general application. You can't single out Indians for laws of general application in the province. And and then under the more general provisions, the federal government has not been willing at all to occupy any space for Indians. They want to assimilate Indians. That's what this hour is about. Section 88 is about the assimilation of Indians, and here's how it's accomplished in law speak, or in chapter and verse through Section 88 of the Indian Act. You just remove all the powers. And this, in fact, this cooperative federalism is the cooperation of the province and the federal government to get rid of Indians. Maybe that's harsh. But that's the effect. Maybe it's not, it might be the intent even, but it's certainly the effect. Cooperative federalism, Indians fall between the cracks of that stuff. They're not found there. There's not like a Section 91 for federal government, Section 92 for provincial government, and a Section 35 for Indian government. If that was the case, cooperative federalism might have some value here, but this is a cooperation that denies agency largely for the people that are being legislated in relation to.
So this also brushes aside or makes irrelevant the argument that under Section 88, there would at least be a prohibition on infringing treaty rights. So
Yes.
the argument being that given the language of Section 88, any provincial law of general application referentially incorporated couldn't infringe any treaty rights. But under Section 35, strangely, you can infringe treaty rights as long as
That's right. So you don't even get the benefit of Section 35's exemption of treaty rights being immune from the application of provincial law. Now through Grassy Narrows, those laws apply to use. So maybe contrary to the will of Parliament, right, which tried to carve out a treaty exception for laws of general application applying to that sphere, we now have the court applying provincial laws to a treaty sphere when Parliament said no. Right? So, I mean, Section 88 is not great, but that had one benefit to it. Even that benefit seems to have been swept away.
To consolidate that, so under Section 88, that you could say the federal government had an intent for that, not for general laws, not to apply to treaty rights, but
That's
then
right.
they've gotten around that through Section 35.
They've gotten around that through Section 35. There's no space for Indian jurisdiction, but not even just like that, no space for Indian jurisdiction, that's the truth. But there's no space for even the province to think about the agency, choices of Indians, right? They can't do it. It's ultra vires. So we're in a mess, right? This is the rock and the hard place of the entire course. I think hopefully you see, after all's been said and done, why it is that there's been such a commotion across the land. Indians are trying to get their voice heard, and you can't actually, through the official structures that are there, get that voice heard. Now, referential incorporation is a kind of a funny animal in Section 88. We haven't talked about this sufficiently, but imagine when the legislature down here in Victoria passes a piece of legislation, not under Grassy Narrows or Tsilhqo'tin, but under Section 88. That is as if it's the Parliament acting down there. That's really strange, don't you think? That we would assume that Victoria is like Ottawa for the purposes of generally applying laws to Indians. I didn't think you were allowed to delegate away your Section 91 or 92 authorities like that. And of course, there's rules under McNeil that kind of fudge this into delegation of powers between spheres.
It's almost as if they would fight tooth and nail for things that they feel is beneficial to them, but then when it comes to something like Aboriginal, like Indian matters, it's like, because federal government is staying silent, they're basically giving allowance to the provincial government to make those laws that
Yes.
affect them. And then they're almost like kind of holding hands together in that they kind of want to assimilate the
Yes.
Indians, and then if they're doing it through this way, well, we're not saying anything, which means seems they have freedom to do it.
Yeah, that's a very good restatement. And I like your holding hands together. You can picture the province and the federal government holding hands together. This is the cooperative federalism, to not really think about the Indians. The federal government doesn't have to think about it. It's the province, and the province can't think about it because it's ultra vires. But think of the wampum belt image I showed earlier, right, of holding hands together. That's not what was meant by that kind of nation-to-nation stuff.
Can we go back to what you were talking about with the Grassy Narrows and its application to treaty? Because I'm a bit confused by this. So now, because of Grassy Narrows, provincial laws can apply to treaty, and from what I understand, the court did not discuss Section 88 here?
Yeah, the court did not discuss Section 88 in the Grassy Narrows case.
But just to correct, I think that should be Tsilhqo'tin. So that's from Tsilhqo'tin.
This 101 is from Tsilhqo'tin,
Yeah.
and Grassy Narrows is taking that
No, I
point.
think that's also 98 to 152 of the paragraphs in Tsilhqo'tin.
Oh, that's from the Tsilhqo'tin
Yeah.
case, okay. Okay. And so this is the Tsilhqo'tin, the Grassy Narrows issue here, limitations on provincial power derived from Section 35 and 9124. Thank you.
I mean, it's weird because the Tsilhqo'tin, as the court says in Tsilhqo'tin, it doesn't have to address this in Tsilhqo'tin. It needs it for Grassy Narrows.
Yes.
For some reason, it decided to put the discussion in Tsilhqo'tin and then
Yeah,
apply it.
that's right, because when we get to Grassy Narrows, it just says, we already talked about this in Tsilhqo'tin. And so that's why this is now referred to as Tsilhqo'tin, because it's not another referential incorporation, but it's like, oh, we talked about that back in the title case. All this title case stuff now applies to treaties, without having the specific question addressed that you're asking. Okay, here's another question. Is Section 88 of the Indian Act an unjustifiable infringement of Aboriginal treaty rights? And the British Columbia Court of Appeal said no. But doesn't Section 88 of the Indian Act cause undue hardship? Deny preferred means of exercising rights, apply unreasonably? And if one of these criteria is met, is Section 88 in pursuance of a valid legislative objective? Is it rationally connected to that objective? Is it minimally impairing? And does the benefit that the federal government / provincial government receives more than the burden of the Indians? We haven't gone down that path because Alphonse has so far said no. I actually forget the reasoning in Alphonse. But that's a pretty high-level court. But it could come back to the Supreme Court of Canada one day. So now, because of Tsilhqo'tin and Grassy Narrows, given that there's a supercharging of provincial power under 9124, it's so hard to say that, provincial power under 9124, it's because it's the provincial stuff is referentially incorporated as federal law. So it's really the federal power that is the provincial power. You wonder if this analysis would ever apply. But of course, provinces couldn't have a valid legislative objective in relationship to Indians, because that would be ultra vires. I'm sorry. This is now just getting crazy. So what are the alternatives? You've got this Central Coast Initiative going from the north of Vancouver Island up to Prince Rupert, where there are 10 different First Nations that are operating exercise provincial authorities through agreement. So, managing fisheries, wildlife area, looking to ensure that forests are being conserved is happening by the provincial government giving over to the First Nations government the enforcement mechanisms. And there's a great clip, we don't have time. But this guy, Art Sterritt, won an award from Stanford University. And if you watch that, I think you'll be inspired. It's a 7-minute clip about what's happened here to see how First Nations are actually doing. Why does the province allow this? Because the province is trying to save money. They don't want their pay for the conservation officers, and they don't want all the infrastructure in this area, because there's already Indians here. Why not let the Indians do that? So they sign an agreement. And then when they sign that agreement and the Indians interpret what their responsibilities are under that federal provincial law, they have all their own values and laws infuse that. So they feast and they potlatch and use their own language, etc.
Do the Coastal Guardian Watchmen operate under this sort of?
This is what this is. This is the Coastal Guardian. I couldn't think of the word. What's it? Coastal Guardian?
Watchmen.
Coastal Guardian Watchmen is what I'm describing here. This is the network that allows for this kind of enforcement. Now, it's not uncontroversial, because why aren't the First Nations there exercising this in accordance with Section 35 powers? Or why didn't the federal government sort of recognize their ability to manage their own lands? Here we've got the province entering into agreement with First Nations. But the effect is very positive by and large. There will be people that will disagree. There's always differences of opinion in any political community, including Indigenous communities. But there's one example. Another example of federalism is through modern treaties. And so if you look at the Niska Agreement, for instance, you'll see all sorts of areas where First Nations have co-equal power with the provinces and will exercise authorities which are generally considered to be federal authorities. And then there's even instances where there's a paramountcy provision where the First Nations can act to kind of kick out the provincial authority. But it's more under those 9124 instances where the Niska is entering it. Although they're not using 9124 language, they're using Section 35.1 language. So there's federalism regimes across the country under modern treaties, which is another alternative. So one alternative is the Coastal Guardian Watchmen Network. Just deal with the province directly, pragmatically, take on those 92 powers, and then just use your own law to exercise enforcement. This is, through negotiation, setting out chapter and verse as to when federal, provincial, First Nations authority applies. And then you've got this example from the United States where tribes not only preempt any state authority on the reservation through their own sovereignty. The preemption is also supported by Congress acting to oust any state jurisdiction. That means that here in these states, tribes not only exercise authority on the reserve exclusively for fish and wildlife and harvesting and other governance matters, education, health care, law, but off of the reserve, they also share with the state government authorities for conservation that flows from their own treaty rights, their own sovereignty, and congressional recognition. So imagine in Canada here, say at UVic, the Douglas Treaties allowed Salish law to apply in this place, and it would be a responsibility for both the province and the Salish to make sure that this land is treated well, and you can read all about those agreements. Here's an example in the United States of all the laws that Congress have passed to oust state jurisdiction. Since 1969 since President Nixon, there's never been a law that's passed by Congress that's been opposed by Indians. Why? Because the Congress passes laws that don't give the authority over to the states, aka the provinces. Congress passes laws where in child welfare, Indians have exclusive jurisdiction for that on their reserves, even have jurisdiction throughout the country wherever their members are located. So in Michigan, if you're a tribe there and there's an adoption or custody proceeding, your tribe would have the right to deal with that with your social workers and through your courts. But if you had a Michigan tribal member down in California, your jurisdiction would also run to that member in that other place. Jurisdiction for religion, resource use, you can see the different types of resources, education, governance, law, including tribal courts, financing, culture, and all sorts of heritage issues like the Grace Islet issue. That would be dealt with under congressional law, not the BC Heritage Act. There would be a parliamentary law in our case. And then social issues, family violence, alcoholism, substance abuse, Indian health care. Here's an example of paramountcy. So here's a legislative example. ousting the jurisdiction. This is an example of treaty, and this is an example of agreement. So there are alternatives. Those alternatives happen right now to be in the crazy referential incorporation world. So that's it. We won't see you until next Monday, but you will get your quiz tomorrow in your mailbox for those who are participating in